Good morning, everyone. Good morning to everyone here in Carson City, as well as those in Las Vegas, and of course, anyone watching online through Nellis or our legislative YouTube channel. With that, Committee Secretary, please take the roll.
Assembly members Cole, here. Dahlia, here. Gonzalez, here. Gray, Hanson, here. Hardy, here. LaRue Hatch, here. Marzola, present. Moore, here. Nadeem, present. Orent-Licker, here. Roth, here. Urick, here. Chair Miller.
Here, and please mark Assemblymember Gray absent excused. With that, just a few reminders. Please make sure that you turn down your electronic devices so as not to be disruptive during the meetings. We will have 3 bill hearings today and then public comment at the end. Asking that those presenting bills keep their comments to their presentations to 15 minutes, and those making public comment or testifying on a bill keep their comments to 2 minutes. I also will remind you to please make sure you state your name and spell it for the record the first time you speak. The phone number to call in if you will testify or make public comment by phone today, the phone number is 1-888-475-4499, and the meeting ID for today is 885-277-19823. And with that, we are ready to begin, so I will take the bills in order today. We will begin with Senate Bill 7, which revises provisions relating to pre-sentence investigations and reports. And with that, your hearing is open, so whenever, I'll give you a few moments to settle in, and whenever you and your co-presenter are ready, you may proceed.
Good afternoon, Chair Miller, members of the committee. I am Tamara Jackson, T-A-M-R-A-H, J-A-C-K-S-O-N, the Department of Public Safety Parole and Probation Chief. Joining us in Las Vegas is Deputy Chief James Schubert. We want to thank you for allowing us to present SB 7 to the committee. I will provide a short synopsis of why we brought this forward and then review each section. The Parole and Probation Division is seeking revisions related to pre-sentence investigation reports. Pre-sentence investigations are required on all felony convictions with few exceptions and may be ordered by the court for convictions of gross misdemeanors. These investigations are intended to provide the court with an impartial view of the defendant to assist in determining an appropriate sentence. Since 1997, NRS 176A-100 has allowed the division 45 days to complete a pre-sentence investigation report. In 2013, NRS 176153 required the division to provide the completed report 14 days prior to sentencing. These statutes are independent of each other, and the division does not believe one should impact the other. Unfortunately, it is somewhat common for sentencing to be set 45 days from adjudication, leaving the division only 31 days to complete the PSI. The limited timeline makes it difficult to produce an accurate, well-investigated report and places a hefty burden on victims to provide receipts and/or appropriate documentation for restitution purposes. There is also an issue related to completion and receipt of psychosexual evaluations by qualified clinicians when timelines are shortened. The division is tasked to schedule psychosexual evaluations as quickly as possible, but cannot control the availability of clinicians nor their subsequent completion of the evaluation, which must be included in the pre-sentence investigation report. These issues have occasionally led to our personnel being berated in court, and even at times threatened with being held in contempt when we requested additional time or were unable to complete the report in the time required to allow for the 14-day disclosure period. Working with our public defenders and district attorneys, we came to an agreeable compromise. And before you is SB 7. Section 1 provides additional options for waivers of PSIs under certain circumstances. In addition, if the psychosexual evaluation is not received by the division in time, the PSI report may be submitted without the evaluation and provides that division personnel would not be held in contempt. Section 2 reduces the disclosure period from 14 days to 7 days, and Section 3 reiterates that if the report is not submitted within 45 days, the court may grant probation without the report. There is a conceptual amendment, which I believe you all have, further modifying the language in Section 3 to include the sentencing court, along with the county clerk, to address differences among the different counties and jurisdictions. Thank you again for allowing us to present this piece of legislation to the committee, and we welcome your questions.
Thank you so much for your presentation. I just have a question out of curiosity. How many professionals do we have in Nevada that are qualified to perform these psychosexual evaluations? And maybe which professionals are able to provide those?
Tamara Jackson for the record. I do not have the exact number. I believe it is 4 in the north and 3 or 4 in the south. They have to meet certain qualifications and have to have certain certifications, and then they have to be approved through the state vendor, as I recall, as well. So properly insured.
Thank you. Are they generally, I'm imagining, are they psychiatrists? Are they counselors, therapists, doctors? What are they? Do you know offhand? I'm just curious.
Tamara Jackson for the record. I think they have to be psychologists, but I would have to follow up and get you that information.
Okay, so psychologists. Okay, thank you. I don't right now see any questions from any members, so I will go ahead and open it up. I do have a question. Assemblymember Nadeem.
Thank you so much, Chair. Thank you for the presentation. So I just want to ask you, what is the current period that the report should be provided as of now?
Tamara Jackson for the record. Could you repeat? Sorry.
Yeah, what is the current period that the report should be provided?
Tamara Jackson for the record. Currently, when we get notified, we are supposed to have the 45 days to complete the report, and then there's a current 14-day disclosure period to allow for any corrections or modifications that need to be made. That 14-day period, we're looking at changing that to a 7-day period, which is fairly consistent with at least the 11 western states for disclosure periods. We looked at it, and some are as little as 48 hours, and we were actually at the highest time frame with 14 days.
Okay, and the 45-day period
Do you
is
want
the
to
same?
follow up, Assemblymember?
Yes, please, Chair.
Proceed.
Thank you so much, Madam Chair. So the 45-day period is the same. It's not changed.
Tamara Jackson for the record, yes. The 45 days hasn't changed. We're just reducing the disclosure period.
Okay, thank you.
Okay, not seeing any additional questions, we'll go ahead and open it up for testimony in support of Senate Bill 7, beginning here in Carson City.
Good morning, Chair Miller, members of the Assembly Judiciary, Paloma Guerrero, P-A-L-O-M-A, G-U-E-R-R-E-R-O, on behalf of the Clark County Public Defender's Office. We are in support of this bill after the amendments that were made, and we want to thank Chief Jackson for her collaboration on this. Thank you.
Thank you.
Good morning, Chair Miller and members of the committee. Jennifer Noble, Jennifer-Noble, on behalf of the Nevada District Attorneys Association in support of Senate Bill 7, and I echo Ms. Guerrero's comments. Thank you.
Thank you. Is there anyone else here in Carson City? Down there in Las Vegas, are you testifying in support? Okay, is there anyone there in Las Vegas to testify in support? Sir, what are you part of the presentation? Yes, so I'm going to have you go back and sit just in case other people wish to come up and testify. Okay, thank you. Broadcasting, will you open the lines, please, for support testimony?
Chair, the public line is open and working. There are no callers at this time.
Okay, thank you. Then I will open it up for testimony in opposition, beginning here in Carson City. Not seeing anyone. Is there anyone there in Las Vegas? Not seeing anyone. Broadcasting, will you open the lines, please?
The public line is open and working. There are no callers to testify at this time.
Okay, next we will open it up for neutral testimony, beginning here in Carson City. Not seeing anyone. Is there anyone there in Las Vegas that would testify in neutral? Also not seeing anyone. Broadcasting, will you please open the lines?
Chair, the public line is open and working. There are no callers to testify at this time.
Okay, thank you so much. Then I will welcome our presenter back up. I actually just want to get, I believe I know the answer, but we're seeking clarity for the record, okay? So just to be certain, the amendment that you mentioned, an amendment, the proposed amendment, this one for submitted by the Second Judicial District Court, April 24th, that's your amendment, correct?
Tamara Jackson for the record. Yes, that is the amendment I'm referencing.
Okay, were there any other amendments submitted that you know of? Because,
Tamara Jackson for the record, not
this
that I'm
is the one.
aware of.
Okay.
And I did have an answer for that other question. If
okay,
you would like.
can we get to that in just a moment? I just want to make sure. So I heard that Jessica Ferrata submitted, is this the same amendment?
Tamara Jackson for the record. Yes, it is the same amendment.
That's what I thought. Thank you so much. And go ahead if you have another answer for another question.
Tamara Jackson for the record. Those that can do psychosexual evaluations are marriage and family therapist, psychiatrist, psychologist, and anyone that meets the training criteria and has the proper certifications.
Thank you so much. So that would be additional training in addition to their professional licenses.
Tamara Jackson for the record. That is correct.
Okay, thank you so much. All right, with that, I will go ahead and close the hearing on Senate Bill 7. Next up, we have Senate Bill 20, which revises provisions relating to criminal procedure. And Mr. McCormick, whenever you're ready, proceed.
Thank you. Good morning, Chair, members of the committee. My name is John McCormick, John, MCCORMICK, Assistant Court Administrator at the Supreme Court, and I'm here to present the first reprint of Senate Bill 20. This bill does two things at this juncture. The first being it removes a 1967 statute that required jury trials in justice court to be reported by a court reporter. So that was the status quo from 1967 to 1989. In 1989, the United States Supreme Court decided a case called Blanton versus North Las Vegas that said you were not entitled to a jury trial if the penalties were de minimis, meaning not significant. So that was then the state of play in 1989 to 2019. And in 2019, the Nevada Supreme Court, decided a case, Anderson versus 8th Judicial District Court, which requires a jury trial for a domestic violence misdemeanor because of the non-de minimis nature of the gun right consequences that attach. So then this statute then became a thing again when the jury trial requirement came back in. And it's the only jury proceeding, or it's the only trial proceeding in the state that has to be reported by a court reporter. All other trial proceedings can be recorded through audio-visual means. And effectively what this has created is a situation where I received a call from a rural judge who was like, I can't find a court reporter and I need to have a domestic violence misdemeanor jury trial. And it put the judge in the position of deciding whether or not to follow this statute that in our mind is somewhat antiquated, or honor that defendant's speedy trial, due process, etc. rights. So this bill cleans that up and then just provides that those jury trials in justice court can be recorded through audiovisual means, that being our standard recording systems, Jefferson Audiovisual Systems. It's not a plug, it's just the name of the primary vendor that provides those systems. And then this bill also provides some clarity on how long recordings of preliminary hearings have to be retained. So that is SB 20, and I'm happy to answer questions.
I'm giving members a few moments to. Okay, so I'll start. So you first mentioned or you lastly mentioned the portion of the bill that would require the recordings to be kept for at least 5 years. What is industry standard? What are other states doing?
Excuse me, John McCormick for the record. It's sort of all over the map, honestly, and it depends on the individual state's statutory schemes. This, I think, would give us a pretty solid, for lack of a better term, retention period for those preliminary hearing recordings. Again, it's sort of all over the map.
What about when it comes to like appeals? Does it align with any type of?
The preliminary hearing recording, so the preliminary hearing being the initial thing where where the judge is determining if there's probable cause to believe that an offense occurred and there is probable cause to believe the defendant may have committed it. So that's that preliminary, that's that first airing. We would record that, and then it would go to trial, and generally, the trial record would be kept, and if it's a district court felony trial, that's a permanent record. And so that would generally be the record that the appeal's based on. If there were issues raised from the preliminary hearing, that transcript would have been provided to the district court and then be part of the record, part of the record to go up to the Supreme Court. So it won't create a record issue, for lack of a better term.
So you said if there were concerns coming out of the preliminary hearing, but we may not realize there are concerns until we get to the appeal process. Would that be possible?
John McCormick for the record. I don't believe so. Generally, those preliminary hearing issues, and there's some case law in the state about the importance of preliminary hearing, and in Nevada, full confrontation clause rights attached at a preliminary hearing. There's a case, and I don't remember it, from a few years back. I can provide the site later, that says if the defendant was afforded full confrontation rights at a preliminary hearing, that testimony may be brought in at the district court level during the trial if the witness is not available at the district court. So it shouldn't necessarily create any sort of record issue. And actually, right now there is no. The record provisions are also covered by, the Supreme Court's record retention schedule for trial courts, and so this syncs up with that, and it's just sort of a little backstop on it.
I also think that I heard your intention with the bill, but I want to make sure, because now I'm thinking it could be otherwise. In Section 3, it says any proceeding before a jury in justice court. Is the word before a preposition or an adjective? Are we saying before I get to a jury or in front of a jury? Because I know in court, before means in front of, so.
Thank you, Chair. John McCormick for the record. And yes, that's in front of a jury.
Okay.
So that would be those limited misdemeanor domestic battery trials at this juncture.
Okay, thank you for that. With that, we have another question from Assemblymember LaRue Hatch.
Thank you, Chair. Just this line of questioning just spurred another. I think that this makes a whole lot of sense, and I appreciate your explanation. My question is just more in general. I know I've heard there are struggles to get court reporters in general, and so my question is just how are we preserving the record through the recording equipment? Is it just anyone can view it when they want? Is it transcribed? What's the next step?
Thank you, John McCormick for the record. On that audio-visual recording, the video and audio of what occurred in the courtroom, and then if that record is needed, that can be transcribed. There are a few different ways to do that. There are services that courts can go out to and have them transcribe the record. They can engage a court reporter, or there's provisions that allow a qualified person on staff to do that transcript. So that's how that record is made from that jury trial.
Thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair. Good morning. Thank you for being here. My question is just more along the lines, it deleted sections 1, 2, and 3. I was looking at the original the bill the way it came out originally. And looks like some substantial things were deleted. I was just curious, can you kind of give us a synopsis of, well, maybe I'm putting you on the spot there. I guess maybe where did the amendment come from?
Thank you, John McCormick, for the record. Initially, this bill tried to do a few things. One of the things it was trying to address is what we call a dangling misdemeanor. So,
Were you trying to get a new term for that, or just?
no, I kind of like dangling misdemeanor personally, but anyway. So what it currently, in the event that there's an incident that generates both misdemeanor and felony and gross misdemeanor charges. Currently, there's a statutory thing, those have to be charged on the same complaint, so then sometimes we end up with a preliminary hearing in justice court, and then the felony and gross misdemeanor charges go up to the district court for adjudication, but that misdemeanor is kind of hanging out at justice court, and not necessarily being disposed immediately, and so that was what it was trying to address, but logistically and through practice for public defenders, DAs, and the court, it became apparent that there was not really a great statutory solution that we could come up collectively to address that issue. So working with the PDs and the DAs, we went ahead and did this amendment to pare it down to making sure that we're able to kind of do SOP on recording of limited jurisdiction jury trials.
Okay, thank you. We have another question from Assemblymember Nadeem.
Thank you so much, Madam Chair. So my question is that in the bill, it says the sound recording must be preserved for 5 years. So is that in line with all the other cases? In the other cases, is it preserved for 5 years?
Excuse me. Thank you for the record, John McCormick. The preservation of various records is sort of dependent on the importance of that. We have, the Supreme Court's promulgated a record retention schedule. We have two, actually. We have one for administrative records, which would not apply here, and then we have one for sort of adjudicatory records at both the district and limited jurisdiction levels. Generally, sort of rule of thumb-ish, without getting into the specifics, most district court records are permanent. Generally, limited jurisdiction records go from any permanent to 7 years is generally sort of the minimum retention for that kind of stuff as far as the adjudicatory records, because 7 years is the mark when misdemeanors, that's the time frame for enhancement, right? So if you've committed one DUI and then 4 years later get another, it's enhanced as a second DUI pursuant to statute. So that's where that sort of limited jurisdiction retention comes from. But yeah, that's actually probably for a sort of on the high end. I would wager that retaining that preliminary hearing. And so it's just, again, it's a statutory backstop.
Okay, thank you. Not seeing any additional questions, we'll go ahead and open it up for testimony, beginning here in Carson City, in support of Senate Bill 20. Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone. Broadcasting, will you open the lines?
Chair, the public line is open and working. There are no callers at this time.
Okay, thank you. Then I will open it up for testimony in opposition of SB 20. Not seeing anyone here in Las Vegas or Carson. Messed that one up. Here in Carson, or got my prepositions wrong. Here in Carson or Las Vegas. Broadcasting, will you open the lines, please?
The public line is open and working. There are no callers at this time.
Thank you. Is there anyone that would like to testify in neutral? Not seeing anyone here in Carson or in Las Vegas. Broadcasting, will you open the lines?
The public line is open and working. There are no callers at this time.
Okay, thank you so much. And there are no final remarks from our presenter, so I will go ahead and close the bill hearing on Senate Bill 20. Next, we have Senate Bill 66, which revises provisions governing certain post-conviction petitions for a writ of habeas corpus. And so I'll give you both a few minutes to get settled in, and then whenever you are ready, please proceed.
Good morning. My name is Heather Proctor, Heather Procter. I'm a Chief Deputy with the Nevada Attorney General's Office. Joining me in Las Vegas is Jamie Stills, who will be presenting this bill this morning.
Good morning, Chair Miller and members of the committee. For the record, Jamie Stills, Jaimie Stilz, Senior Deputy with the Nevada Attorney General's Office. SB 66 is a proposed change to Nevada statute that governs venue for habeas petitions. There are two types of habeas petitions in the state. The first is when an individual challenges their criminal conviction and sentence. The second is when an individual challenges the computation of time served in the Nevada Department of Corrections, such as the time they must serve on their minimum sentence before they are eligible for parole, or the time they must serve on their maximum sentence to complete that sentence. NRS 34.738 dictates which county each type of petition is filed. SB 66 amendment only addresses the computation of time petitions. Under existing law, the individual must file a time computation petition in the county of incarceration, or, if incarcerated outside of Nevada, in the First Judicial District Court in Carson City. This bill addresses when the individual is no longer in the department's custody, such as parolees. We have seen an increase in the number of parolees challenging the calculation of their maximum sentence, which impacts when their sentence will expire. However, because these individuals are no longer incarcerated, there is no provision under existing law as to where they must file their petitions. This leads to confusion for both the individuals and the courts regarding how and where to file their time computation petitions. SB 66 provides that those no longer incarcerated will file their petitions in the county in which they reside, or in the First Judicial District Court if they no longer live in Nevada. We hope this bill will serve to address all situations in which an individual seeks to file a credit calculation petition. Thank you, and I am happy to take any questions the committee members may have.
Thank you so much. Just giving members a moment to consider any questions. And it doesn't look like we have any questions, so I'll go ahead and open it up for testimony. Beginning here in Carson City, anyone wishing to testify in support of Senate Bill 66? Not seeing anyone? Is there anyone there in Las Vegas that would like to testify in support? Actually, is there anyone else there in Las Vegas, period? No. Okay. Broadcasting, will you please open the lines?
The public line is open and working. There are no callers at this time.
All right, thank you. Then I will open it up for testimony in opposition of Senate Bill 66. Not seeing anyone here in Carson or Las Vegas. Broadcasting, will you open the lines?
The public line is open and working. There are no callers at this time.
Thank you. Then I will open it up for neutral testimony. Not seeing anyone here in Carson City or Las Vegas. Broadcasting, will you please open the lines?
The public line is open and working. There are no callers at this time.
All right, thank you. Then with that, I will invite the bill presenters to make any final remarks. Okay, thank you so much. Then with that, I will go ahead and close the hearing on Senate Bill 66. Last on our agenda is public comment. So anyone here wishing to make public comment? Not seeing anyone in Carson or Las Vegas. Broadcasting, will you please open the lines?
Chair, the public line is open and working. There are no callers to provide public comment at this time.
Okay, thank you so much. Then with that, I'll close public comment, and that concludes our agenda today. Or tomorrow, and I'm scared to say this, but we'll try it. We'll start at 8:30 a.m. This meeting is adjourned.